Hello and welcome to the Worcester Senior Center and the Government Station Channel 192 for Worcester Senior Center Stay Connected programming. I'm Amy Vogel-Waters, Director of the Worcester Senior Center. We continue our Distinguished Speaker Series today in collaboration with the Worcester Jewish Community Center, welcoming back Attorney John S. Ross III and Honorable Martha P. Grace. Our program today focuses on this year's United States Supreme Court term, which promises to be a controversial one, including taking up a new case on abortion. Attorney Jack Ross and the Honorable Martha Grace will discuss the constitutional dimensions of the abortion debate, the background of Roe v. Wade, how we got to this point, and what the Supreme Court might do. It's now my pleasure to introduce the Honorable Martha P. Grace, who was appointed as Chief Justice of the Massachusetts Juvenile Court in February 1998, retiring from the Massachusetts Trial Court in 2009. Prior to that, she had been Associate Justice of the Worcester Juvenile Court since 1990. She received a bachelor's degree from Smith College, a master's degree from Clark University, and a Juris Doctor from New England Law School. In addition, in 2011, Judge Grace received a Master's of Science degree from Tufts Cummings School of Veterinary Medicine's Animals and Public Policy program. She currently teaches animal law at the Tufts Vet School in Grafton, Mass. Before we hear from Judge Grace, please welcome Nancy Greenberg, Cultural Arts Director at the Worcester JCC, who arranged this event with our program coordinator, Suki Lapin. I thank them both and invite Nancy to say a few words.
Thank you, Amy. The Worcester Senior Center and the Worcester JCC have a long history of collaboration. I'd like to thank my colleague and my trusted colleague and dear friend, Suki Lapin, for being a programming partner extraordinaire. It's thrilling to have a live audience for today's program. Jack Ross. John S. Ross III, better known as Jack, earned his undergraduate degree from Yale University, his JD from the University of Virginia School of Law, and a degree in taxation from NYU School of Law. He practiced law for many years in Washington, D.C. Jack has taught numerous courses in the WISE program, Worcester Institute for Senior Education, focusing on constitutional law and the Supreme Court. He also facilitates the WISE Supreme Court Special Interest Group. Welcome, Martha and Jack.
Jack Ross and I are happy to be back with you to discuss the current status of the constitutional right to an abortion and provide you with an update on the pending cases in the Supreme Court. As you know, last week the United States Supreme Court heard oral arguments on a Mississippi case called Dobbs versus Jackson Women's Health Organization. The day after the oral arguments in the Supreme Court, based on the comments of a number of the justices, the newspapers and all media outlets were crackling with speculation that the Supreme Court might well overturn Roe v. Wade, which has essentially governed abortion rights since 1973. Dobbs versus Women's Health, Jackson Women's Health, involved the constitutionality of a 2018 Mississippi state law that bans abortions after 15 weeks of pregnancy. Roe v. Wade has stood for almost 50 years, but now everyone is watching this case very closely because in recent years, the makeup of the Supreme Court has shifted sharply to the right, and we now have a majority of conservative justices who have indicated that they might well overturn this landmark precedent. If the court follows its customary practice, we'll probably not even get a decision until next June. But as Jack will explain, it's always hazardous to predict what justices will do, even based on the oral arguments. But the well-known positions of these conservative justices and some of their comments during the oral arguments have raised concerns over what might happen. Today, we're going to start with Roe v. Wade as well as several other cases following Roe that upheld but significantly modified the Roe ruling. This background is helpful as you will see the cases coming forward in the Supreme Court. It would be hard to find a topic more controversial in American society than the topic of abortion, and fewer cases have been more controversial than Roe. So Jack, before we turn to Roe v. Wade, would you like to make some additional comments?
Thank you, Martha, and it's great to be here today. Some time ago, Martha and Suki and Nancy and I were talking about doing another program, and we thought it would be a good idea to find a non-controversial topic, so we came up with abortion. So, but at any rate, yeah, I just wanted to make a couple points before we get into sort of the meat and potatoes of this. First of all, we're talking today just about the constitutional framework of abortion rights, not about abortion itself, which, as we all know, is a highly charged, emotional, political, religious issue. That's not our focus today. And one other thing I'd like to add, even though we're going to start with Roe v. Wade and move forward, it's also important to know that there was a long history of abortion in the United States way before Roe v. Wade, right? In fact, you know, under the common law, going back to England, that was adopted in this country, the rule was that a woman could have an abortion up to the point of quickening, which is when she felt something move in her, you know, in the womb. That was the common law rule that stood until the late 19th century and early 20th century, when a number of states started to enact laws restricting or even criminalizing abortion. So I just wanted to throw that out because that's an important, you know, context for today. So, you know, and part of what led to Roe v. Wade then was changes in the 50s and 60s, partly due to the feminist movement, attitudes in society about all these things were changing. And it all came to a head, as Martha will talk a little bit more, with the Roe v. Wade decision.
Thank you. Okay, Roe v. Wade was decided in 1973, and as Jack just explained, there was some other law going on, but Roe v. Wade created a national uproar. It was a landmark decision in the United States in which the Supreme Court ruled that the Constitution protected a woman's right to have an abortion without excessive government restriction. It prompted a national emotional backlash. And now, close to 50 years later, the debate continues. Briefly, the case involved a woman known as Jane Roe, that was a pseudonym, who was pregnant with her third child. She wanted an abortion, but she lived in Texas, where abortions were illegal, except when it was necessary to save a woman's life. She filed a lawsuit in federal court challenging the Texas law on constitutional grounds. The lower court in Texas ruled in favor of her, but Texas appealed to the Supreme Court, which ruled 7-2 that the Due Process Clause of the 14th Amendment of the United States Constitution provided a right to privacy that protected a woman's right to choose whether or not to have an abortion. Jack, almost everybody has heard of Roe v. Wade, but not everybody knows the details. Can you explain what it created such an uproar and continues to do so all these years later?
Sure, Martha, thanks. I'll try to just briefly hit a few points because obviously you could talk about these things for hours. But as I already noted, the country was already divided on abortion by the time the Supreme Court decided Roe v. Wade. Some states had liberalized their laws. So there was a lot going on in different states on the issue of abortion rights and that type of thing. So as a result, when the court decided its decision, made its decision in Roe v. Wade, obviously there was going to be a backlash one way or the other, no matter what the court had decided, because there was already a sharp division in the country. Now, one of the issues was people thought that, and still do think that, as a matter of states' rights and federalism, these issues should be decided by state legislatures and not by federal courts. So that's always been one part of the debate with Roe v. Wade. There was also disagreement that the court could suddenly, come up with this, what some people call this new constitutional right. There's nothing in the Constitution about abortion. There's nothing in the Constitution specifically about a right to privacy. But over the years, the court had carved out some of these concepts. So those were some of the major objections to the decision.
Jack, what did the court actually say about the right to an abortion?
Well, briefly, a couple things. First of all, the court looked to some of its prior decisions, and even though, there's nothing explicitly in the Constitution about abortion, found that some of its prior decisions had created sort of a right of privacy, okay, that particularly in the marital area, some of the cases. And they extended that in Roe v. Wade, and they said that a woman has this right of privacy, autonomy to make decisions for herself, to control what happens to her, her body, her future, all those things. That was sort of the foundation of the court's decision in Roe v. Wade. And that was all based, again, as you said, on the 14th Amendment, the Due Process Clause.
All right, so if Roe v. Wade that found that the right to privacy was the principle on which a woman's could assert her right to abortion, isn't it true, though, that the right to privacy was not absolute? What were the other interests that the court considered?
Yeah, and that's really important, and this is what we heard a lot about in the oral argument last week. The other big interest here is the state's interest in protecting an unborn child, okay? And so what the Supreme Court in Roe v. Wade had to do was it had to balance those two interests. It's, on the one hand, you have the woman's right to make decisions about herself, the state's right to protect an unborn child, and the way they came out with that was, as everyone I'm sure is familiar with, the trimester approach, which broke it down so that basically during the first trimester of pregnancy, the woman pretty much has an unfettered right to choose what to do. During the second trimester, the state has the right to regulate abortion if necessary to protect the woman's health, but can't deprive her of a choice. But in the third trimester, after the point of what's called viability, then everything changes, and then the state's interest becomes paramount and outweighs the woman's right to choose. So that was what they essentially came up with in Roe v. Wade.
Okay. We've also heard that Justice Ruth Bader Ginsburg disagreed with the Supreme Court's ruling in Roe. And some people have even speculated that were she still alive, she might vote to overturn the case. We don't agree, we don't see that, but can you explain what Justice Ginsburg's views were and why people are confused about this?
There's been a lot of misinformation, to be honest with you, about this point. In fact, the state of Mississippi in its brief in the Supreme Court mentioned Ginsburg's views, things she had written about Roe v. Wade as part of their case. The fact of the matter is, Justice Ginsburg was always a staunch supporter of abortion rights. But as an academic, in some of the things she wrote, she approached it a little differently. And her feeling was that maybe the Supreme Court would have been on better ground in Roe v. Wade if, rather than grounding its decision on the right to privacy, it had actually grounded its decision on the Equal Protection Clause of the Constitution, which she was a pioneer in expanding in different contexts. That doesn't mean that she didn't ardently, support women's rights to abortion. It just means she thought the court might have gone a different direction, and had it done so, in her view, maybe been on a little more solid ground.
Okay, so what was the principal objection to the Roe decision, and is that objection still the same today?
Well, there are a number of objections, obviously, and they range from legal to social, political, philosophical, religious. And again, we're trying today just to focus on sort of the constitutional framework. One of the big ones, Martha, as you know, is the criticism of the right of privacy. Where did that come from? This criticism that it doesn't specifically exist anywhere in the Constitution. And this gets to the general debate that you may have heard about. There are different schools of constitutional interpretation, right? And one school are the so-called originalists, and the late Justice Antonin Scalia was a prominent so-called originalist. Clarence Thomas is an originalist. Alito is probably a little bit along those lines. And those people believe that constitutional interpretation should be based on what the Constitution says and what the people who wrote the Constitution would have thought about the issue at that time. Okay. So those people would say you can't just come up with these new rights that were never there to begin with. Okay, the other school of constitutional interpretation is what's often called the living Constitution. The fact that the Constitution has to bend and be interpreted over time to reflect changes in the country, okay? And those people would say it's perfectly appropriate to find this kind of general right of privacy and autonomy in the Due Process Clause of the 14th Amendment. Finally, as I mentioned earlier, another objection has been the so-called states' rights thing. That this should be just a matter of states' rights, state legislatures, let the people decide. One problem with that argument, and it is a powerful argument, is that if you take that to its extreme, then anytime you have a constitutional right, state legislatures would be able to override it. And that's not the way our system works, right?
Yes.
The Supreme Court decides what the Constitution means.
Yes, thank you. Okay, we're going to turn to our next case, which is Planned Parenthood versus Casey, decided in 1992. Now, although there were a number of other cases after Roe and before Casey, this case was, again, an important case and somewhat controversial. And it was almost 20 years later after Roe. In Planned Parenthood versus Casey, the Supreme Court reaffirmed Roe v. Wade, but did so on somewhat different grounds. And it affirmed Roe v. Wade, but differed in certain respects. The Supreme Court reviewed a Pennsylvania law that imposed various restrictions on a woman's right to abortion. One provision was she had to sign something saying that she had notified her husband prior to undergoing the procedure. There were also requirements that she be given certain information about the abortion, and that she had to sign what was called informed consent to have an abortion. Jack, Planned Parenthood versus Casey was a pivotal decision that presented a more conservative Supreme Court with an opportunity to reconsider its ruling in Roe. But the court made a narrow decision to uphold Roe with some significant changes to the Roe ruling. Can you describe what was happening in the country at the time and in the courts between Roe and Casey that set the stage for this decision?
Sure, Martha. You know, between 1973 and 1992, a lot was going on in the country politically, socially. We had a real wave of conservatism, right? Particularly when Ronald Reagan was elected in 1980, and he really brought kind of the evangelicals into the Republican Party in a much more vocal way. The Right to Life movement grew much more vocal. All those things were happening, and at the same time, even though you had a very strong anti-abortion coalition, which was still a minority of the country, and still is, by the way, but a very vocal one. At the same time, you also had a recognition that maybe they couldn't take on Roe v. Wade head on at that time. So what they did was they adopted kind of an approach of incrementalism, meaning that a lot of states began to enact laws that would curb abortion or put restrictions on abortion in different ways without trying to actually challenge the main holding of Roe v. Wade. Okay. So that was what was going on prior to Casey, and as Martha mentioned, some of the restrictions in Casey were representative of what a lot of states were doing, right? Those types of restrictions on abortion and on abortion providers. So that was sort of the background to the Casey decision.
What were the key elements of the Casey ruling? And how did that ruling change the constitutional parameters of the abortion debate?
So basically what Casey did was shift the focus a little bit, and this had a lot to do with, Justice Sandra Day O'Connor, who had already in prior opinions and other cases developed what she called this undue burden approach, which essentially means that states are free to regulate abortion up until the point that a state law creates an undue burden on a woman's right to an abortion, puts a significant obstacle in the path of a woman who wants to have an abortion. So that became now the real focus of the Supreme Court. They also modified the trimester approach a little bit, and they basically said in Casey, states can regulate abortion up until the point that it creates this so-called undue burden. But they did retain the viability line, right, that after viability, a state is free to prohibit abortion. Now, of course, no one quite knew, what an undue burden would be, right? That's the way the law works. It's a case-by-case basis. What's an undue burden in one person's eyes might not be an undue burden in somebody else's eyes.
So, how had the makeup of the court changed between Roe and Casey, and did that make a difference, if any?
Well, in fact, at that time, under Chief Justice William Rehnquist, the court was fairly conservative. And in fact, if you read about what was going on behind the scenes, and we typically don't know this about how the Supreme Court works, but years later, sometimes some of the justices release some of their papers. We know that in fact, they took a preliminary vote, and it was quite possible that they were going to overrule Roe v. Wade in the Casey case, and that didn't happen, mainly because Justices O'Connor, Breyer, and Souter got together and came up with this new approach. So as a result, that clearly was a critical moment.
Okay. There was much discussion in Casey about stare decisis, or the need to adhere to precedent. So my next question after this one is going to be, what did they say about stare decisis in the oral arguments, but what did the Casey court say about stare decisis?
Well, they said a lot, in fact, and for those of you who don't follow the Supreme Court, the principle of stare decisis is just a Latin term that basically means the court should follow its own precedents, its own prior decisions. But of course, like any other doctrine, there are exceptions to that, and the court does overrule its prior decisions. from time to time. But in Casey, what they did was they laid out a really pretty in-depth analysis of, well, when should the court, overrule a prior decision? What are the factors the Supreme Court should look at if it's going to overrule a prior decision? And they talked about things like, has there been a change in the underlying facts? Has there been any overall change in the law? Has the country relied on our prior decision? And the gist of the opinion was that, if the Supreme Court is going to establish constitutional rules that have some stability, then we have to be very careful about just casting them aside.
So, in the oral arguments last week, we heard a lot about stare decisis. It sounds like it cuts both ways.
Well, it can, and we did hear a lot about it from some of the different justices, and Justice Kavanaugh had some very different ideas about stare decisis, about the need to follow precedents, or why at times it makes sense for the court not to follow them. So there's no doubt that this is something the court is going to have to confront one way or the other.
Okay, our third case today is Whole Women's Health versus Hellerstedt in 2016, which was almost 24 years later. In 2013, Texas passed a law placing a number of restrictions on abortion clinics within the state. Two particularly controversial requirements were that doctors performing abortions have admitting privileges at a hospital within 30 miles of the abortion clinics, and that abortion clinics had to have the same standards, medical standards, as those of surgical facilities. The parties who challenged the law contended that these restrictions placed an undue burden on the woman's right to get an abortion. In fact, evidence produced at the trial indicated that all of these abortion clinics would be required to close, leaving women having to travel in excess of several hundred miles to obtain an abortion. Jack, what were the issues in Whole Women's Health, and why was this such an important case? Aren't we chipping away at these restrictions?
So as I said, this wave of kind of incrementalism in various states enacting various laws that put new restrictions and over time maybe some more stringent restrictions on abortions developed to Whole Women's Health, where we had a couple really, really stringent restrictions on abortion clinics, particularly the requirement that a doctor working in an abortion clinic had to have privileges, at a hospital, and the surgical standards requirements. In fact, what happened was most of the clinics really couldn't meet these standards and were just going out of business, to the point where there were only going to be maybe one or two left in the whole state of Texas, which would mean that any woman who wanted an abortion would have to drive hundreds of miles to get one. So that was why this was such a big case.
And what did the Supreme Court decide about this case?
Well, interestingly enough, what the court did was it looked back to its decision in Casey, which we just talked about, right? Which established this so-called undue burden standard. And it said, we think on these facts that this Texas law that created these requirements for abortion centers goes too far and creates an undue burden on a woman's right to an abortion, so they struck the law down.
And once again, how did the makeup of this court in 2016 change or determine the decision?
Well, it was an interesting time, Martha, because as you may recall, after Justice Scalia's death, there was a long period of time before that seat on the court was filled. And so as a result, when this case was decided, there were only 8 justices on the court. And it was an interesting split, right? You had 4 so-called liberal justices, Ginsburg, Breyer, Sotomayor, and Kagan. You had 4 generally conservative justices, Roberts, Thomas, Alito, and Kennedy, although Kennedy was kind of a swing vote. It broke down 5-3 was the decision, and there were, 3 dissenting opinions, and Kennedy was the key vote to strike down the law.
Has the Supreme Court ruled on any other abortion cases since Whole Women's Health? And where does the law stand today? It
did actually, in only, I think, a couple years after Whole Women's Health, almost the identical issue came up in a case that came out of Louisiana, almost an identical statute that had the same types of restrictions. The interesting thing about that case was that the Court of Appeals actually upheld the law, which puzzled some people, but the Supreme Court eventually overruled the Court of Appeals and struck down the law. And interestingly enough, a key vote was Chief Justice Roberts, who basically said, I'm doing this because of the principle of stare decisis. We just recently decided this issue in Whole Women's Health, and we're not going to back off of that decision now.
Okay. All right, so now we've discussed Roe and Casey and Whole Women's Health. Let's turn to some issues about today. As I noticed, there's been considerable speculation that this new, more conservative Supreme Court will use the Dobbs case out of Mississippi to overrule Roe v. Wade. Jack, is there anything in the oral arguments that indicated how the courts might rule?
Well, as you said at the outset, Martha, I've always said it's difficult to predict the result of a decision based on the oral argument. For those of you who don't understand the Supreme Court procedures, by the time they actually do the oral argument, which they did just last week, the justices have already read all the briefs and studied it inside and out and probably have developed their own positions in the case. And then after the oral argument, they met last Friday and probably took a vote. Now, no one knows anything about that yet, but it probably won't be June until we get a decision. And in the intervening time, a lot of things can happen. But yes, to answer your question, I think a lot of observers felt that there were some ominous signs, depending on how you feel about the issue, that yes, they in fact might have 5 votes to overrule Roe v. Wade. But we don't know that for sure.
If the court upholds the Mississippi law, does that mean it automatically must overrule Roe v. Wade, or is there a more narrow ruling that they could impose?
They could conceivably find a middle ground based on the Casey undue burden analysis that we've talked about, possibly, and not go so far as to overrule Roe completely. There's been a lot of speculation about that. In fact, when this case first went on petition to the Supreme Court, Mississippi was arguing something along those lines, and later supplemented their briefs to take on Roe v. Wade head on. So, yeah.
So what do you think about Justice Sonia Sotomayor's very pointed comments that the very, quote, institutional integrity of the Supreme Court is at stake?
Well, there was some criticism of her comments. They were uncharacteristically sharp. There were things in that oral argument that weren't really questions to the lawyers, but seemed like messages from some of the justices to the other justices, and that does happen. I can only say, and this, we'll talk a little more about, what they might do here, but I think that some of these comments are justified if you take the position that there should be more grounds for overruling a major decision like Roe v. Wade than merely the fact that we have some new justices on the court, right? And a lot of people, including myself, don't think that if you follow the traditional analysis that was laid down in Casey, that there's really much ground for overruling Roe. So I think her comments are kind of on point. What does this say about where the court is as an institution today?
Okay, in that vein, during the confirmation hearings of the newest Justice, Amy Coney Barrett. She was asked about her views on abortion. In fact, all the other, or recent justices have also been asked about their views on abortion. Clearly, these questions are designed to determine whether the new justices are likely to vote to overturn Roe. Were any of the justices asked those questions willing to express their views on abortion?
Well, you know, the confirmation process has become quite an involved one, and almost every nominee since Robert Bork has learned the lesson that you don't say very much that could come back to hurt you. For example, don't say there's no right of privacy in the Constitution, which is what Bork said, and his nomination went down. So they're very guarded, and they don't say a lot about hot-button issues like this that could come before the court. Clarence Thomas, I think, even said during his hearings that I've never had a conversation about abortion. Now, some people wondered about that, but that's what he said. So I think that what you have to do is look at what they've done, if they've served on lower courts and had cases that deal with those issues in the past, or if they've written law review articles like Amy Coney Barrett has, and try to get some sense of where they might be on these issues.
Have there been instances, as a general matter, where justices, Supreme Court justices, voted quite differently than that which was expected of them?
It's happened time and time again in history that justices don't always, you know, turn out to be maybe what people thought they were when they were nominated and confirmed. You know, one of the best examples might be Chief Justice Earl Warren, you know, who was considered to be, you know, fairly liberal, right, on many issues, and was appointed by Dwight Eisenhower. And there have been others over the years too. David Souter turned out to be more in the vein of a liberal, and he was appointed by Bush and that type of thing. And Kennedy was always hard to pinpoint. And O'Connor, really, even though she was conservative, she was very balanced and incremental, you know. So you never can tell for sure until a justice has been on the court, I think, for a number of years.
So given what we know about the prior opinions, their law review articles, or anything else, and the oral hearings, how well do you think we can predict what they will do in the coming case?
Again, I think that reading tea leaves can be a little hazardous, right? I remember Jeffrey Toobin pronouncing the evening after they had the argument on the Affordable Care Act case that the Affordable Care Act is going down. And I remember thinking, I don't know, and it didn't, right? So I think right now there's a lot of people saying Roe v. Wade is going down, and I wouldn't bet the farm on that, to be honest with you. It could happen, but it might not. Okay.
And finally, although we have focused today on the Mississippi case, we've heard a lot about this Texas abortion case that effectively has banned abortions in that state. A challenge to that law is pending in the Supreme Court. Jack, very briefly, can you explain what the basic issue is in that case, and how is that likely to be resolved?
So, yeah, this is really confused and complicated, this whole area, over the past, 2-3 months. What happened was that there was a conservative lawyer who was working on behalf of a lot of sort of pro-life groups, came up with a new theory for a state law that would essentially maybe allow a state to effectively ban abortion but avoid federal court review. Okay, and that's what this Texas law was designed to do. And the way they did that was they enacted this law that basically prohibits an abortion after something like 6 weeks, I think, is it? It's a kind of a fetal heartbeat law. But not only that, but the state itself is not the party that's defending the law. It was set up so that it would be essentially enforced by private citizens and almost anybody. You don't even have to live in Texas. You don't even have to be any connected to a woman or her abortion provider at all can file a civil suit for damages. So it's kind of a very unusual law, and the courts weren't quite sure what to make of it. And when it got to the Supreme Court on a procedural motion back in, I think, September maybe, the court did not enter an order that would freeze this law from going into effect, and the court was criticized for not doing that, but the case is still pending in the Supreme Court. My own feeling about this case is that it's a very unusual law. I don't think the Supreme Court, most of the justices probably like it very much. I think they're trying to figure out on what grounds they might strike it down possibly. It creates federal supremacy issues, the federal government versus the states. The U.S. has intervened, and it's a mess, but I think it's going to, my best guess is that this case is going to disappear, and we're going to be focusing on the case out of Mississippi.
Good. Okay, well, we could go on for probably hours, but I think we've run out of time. So I want to thank you to the listening audience, to the live audience. We probably are going to have to wait a number of months before we get a decision on the Mississippi case. But in the meantime, we hope we've given you some background so that when the media coverage will come, as it will, that you'll have some background to understand it. Thank you very much. Thank you, Jack.
Thanks, Martha.